here's the other big part of the connect the dots between pretrial incarceration and sentencing:
Mhm.
coercive plea bargaining.
Yes.
Because you may be innocent or have a really good defense and that you really want to go to trial. And the government a lot of times knows this, and that's one of the reasons they're trying to keep you in custody. Sorry, but that's true. They don't
Yes, it is
really have
true.
a real concern that you're going to flee. They don't really have a real concern that you're a danger. They want a tactical advantage over you, which is to say, I'm going to lock your ass up in this piece of shit pretrial detention, and you're going to be a lot more receptive to the plea offer that I'm
Right.
going to give you. Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. A fine, cloudy Sunday in Arizona. The hurricanes, unfortunately, are hitting the West Coast, and it's very dreary, and it looks like rain here. But what better way to spend a dreary Sunday afternoon than with my very good friend and oh so special colleague, Mark Allenbaugh from sentencingstats.com. Good afternoon, I guess, for you in Ohio. It's good evening,
Yes.
sir. What's shaking?
No hurricanes out here. So
No?
no, not
Okay.
yet. Probably in a few days we'll get whatever you guys have out there. So,
Well, in keeping with my tradition of finding great tequila sponsors to not sponsor this, today is brought to you by Wild Common
well, come.
Reposado. Yes.
Well,
I'd like to try to make these thematic, like how am I going to relate this to the topic that we're talking about? So,
I'm glad you got reposado though. That's good.
well,
Wild common.
yeah, it's a very nice
An
tequila,
English
I
name
guess.
for a tequila.
We could do reposado because, as you know, that means rested. And the topic of today is that unfortunately the subject of our podcast, Sam Bankman-Fried, is now resting
Resting.
in a jail cell. We could do common because in my world, especially as a federal defender for 12 years, it's very common for people to be languishing in jail awaiting trial on a federal case. It
Yeah.
only seems to me that maybe like the whitest collar uh clients, the white collar was that a Freudian slip? White collar clients with a lot of resources and stuff are generally the ones that get to stay out while the case goes on and on and on towards trial or plea or sentencing or appeal or whatever. But it's pretty interesting in the federal courts how many people just gotta stay in jail while their case is getting investigated and worked up for whatever happens. And so what does that have to do with sentencing? I mean, you can relate anything to sentencing, to be honest, but the truth is, if you're in jail, it's akin to a jail sentence. I
Hmm.
mean, you're in jail. And these jails, by the way, they're pretrial detention. They're worse, generally worse conditions.
Yes. Yep.
Um,
Much higher security level than
yeah,
a
it
lot of
sucks.
facilities. Yeah.
Yeah. And so you've been thrown in jail, even though the presumption of innocence still attaches because you haven't necessarily pled guilty or been convicted of anything. So we're talking today about pre-trial detention, and it's in a sort of all the facets there. And really, it does. I mean, if you just want to connect the dots to sentencing, it makes it extremely difficult to help your lawyer prepare a case for trial, prepare a case for sentencing. And once you're in jail, it's like you've already been sentenced. So we're going to talk about that. And what motivated us is the recent news, because Sam Bankman-Fried, the crypto guy, was out on pretrial release, and he just had his pretrial release revoked and now he's in jail. And Mark and I thought it would be a very good opportunity to sort of talk to folks about how all this works and what it is and what the impact is. So we're
Well,
going to have
also,
a conversation about that. Yeah, go ahead,
yeah,
Mark.
but also to, compare and contrast, so to speak, going back to your theme about how some types of offenders do not get pretrial detention and others do.
Yeah.
It's very interesting that, and we'll discuss this, the comparison between SBF, Sam Bankman-Fried, and Trump, because
Mm-hmm.
they seem to be doing, or certainly Sam Bankman-Fried, he was remanded because he was witness tampering,
Yeah.
and that pretty much very plainly appears to be what Trump has been doing,
Yes.
and yet he hasn't been remanded as of yet. And so, we should discuss that too. It's what's the difference between these two, and looking at the judges, and why doesn't, why does one judge remand and another doesn't?
Right.
Yeah.
Right. I mean, the most obvious difference is one's the former president, and I think everybody's walking on eggshells that now he's charged. What do we
Well, they're
do? How
two
do we treat him?
billionaires. I mean, they're two
Well,
billionaires out
I
there.
mean, a case could be
At least
made that that's not true.
true. That's true.
One
At
is
least
one
one was a
left to one.
billionaire.
Yeah, I mean, one is left to wonder if the former president has so much money why he can't afford any lawyers. But I guess that's another podcast. The point is, yeah, with all of the stuff that he's doing and all the potential for violence by his followers, loyal followers, and violence we already know has happened. Yeah, any prosecutor who wanted to make a compelling case that he should be incarcerated pretrial probably could make that case, but they haven't done so thus far. And I do think that's an interesting distinction. So for people who don't know what Sam for the two people out there who don't know about Sam Bankman-Fried, just give me a quick overview. What is he accused of?
Yeah. So Sam Bankman-Fried, he was he ran a cryptocurrency exchange called FTX. And he also founded a market maker. I'm not exactly sure how to describe it, but a sister organization to FTX called Alameda. And that Alameda provided funding for FTX. Anyway, it was a large cryptocurrency exchange, and what he was doing was, what FTX purported to do was, you could invest in cryptocurrency through FTX. It was a stock exchange, if you will, but for cryptocurrencies.
Yeah.
And what it turns out he was doing, or at least what he's been alleged to do, is he was just taking all the investors' money, and he actually was not investing it in cryptocurrencies. He was basically operating a Ponzi scheme, taking early investors' money and taking later investors' money and returning it to early investors, and keeping a big chunk of change, and reporting to investors, providing false reports, financial reports to investors on how their investments in cryptocurrency was doing. And as a result of the FTX's downfall, it really hurt the cryptocurrency market, and created an enormous amount of loss for many, many companies, and even municipalities and countries and sovereign funds that had been investing in this stuff. It was just absolutely enormous. So that's basically the gist of what got him in trouble, and what he has been accused of doing.
Okay.
But his remand is something else that we'll
Yeah. And at the end of the day, I mean, as complicated as we can make this, it's pretty simple. These are just like white collar case.
Yeah.
Conspiracy to commit securities fraud, money laundering, wire fraud, the all too common. Oh, the wild common wire fraud charge. That's
Right.
what we see most of the time. Anyway, so but this is, and I thought it was really interesting too, just because, well, I'm going to start from the very beginning. When you get a federal charge, you are entitled, if the government is seeking detention, and that's another interesting distinction, I think, with the former guy. In my world, what I'm used to, especially for the non-white collar, is a person doesn't get a summons and doesn't get a thing that says, hey, we got this indictment and court's coming. Maybe just show up at the courthouse on this day and we'll work it out. No, in my world, especially as I said about when I was a federal defender, which we're talking about people with little resources. We're talking about people of color. We're talking about people that maybe don't have a stable residence and as much family support and everything else. Blah blah blah. They just put a warrant out for your arrest,
Right.
and then the U.S. Marshals go and they hunt them down, and they find them and they put them in handcuffs and shackles. They bring them to court. They sit in a little holding cell for half a day or more while they get to see the judge. In our district in Arizona, arraignments are 3 p.m. And then you go before a judge for your initial appearance. And at that point, the government is either, we find out, are they seeking detention? In other words, the government wants them in custody the whole time while this case is going on, or will they not seek detention and they'll agree to some release conditions and they'll get out that day if that happens. If the government's seeking detention, you're entitled to a detention hearing. Well, guess what? The government has 3 days under the statute to hold that hearing. So if the government's, all they have to do is stand up that first day and say, I want him detained, then typically the detention hearing's set in a day or 2 or 3. And so a person's sitting in jail for that long to decide if they can even get out. And that happened to me 9 times out of 10, I would say, in the cases that I handled as a federal public defender, the government was seeking detention.
Yeah. And those
And
were
then
what, mostly drug cases?
They were all kinds of cases. Some were drug, some were immigration. Now, if immigration's different because some of those folks didn't have lawful status to be in the country, so if they agree to detention, they'd be taken directly to immigration and deported, which would be great for us because then they wouldn't have to appear. But no, every kind of case. And we had a lot of reservation cases because Major Crimes Act, so it could be some of those are crimes of violence, and those are more understandable if a person's allegedly hurt somebody. I can see where a prosecutor would seek detention, but basically then the detention hearing comes and you can present evidence about why they should be released, and the judge, in order to keep them in custody, has to find that they're either a flight risk or a danger. And if the judge determines either one of those, they can hold them in custody. Right. And so for Sam Bankman-Fried, I don't even know.
And what's the evidentiary standard for that?
Oh, good question. I think for flight risk, it's preponderance, and for danger, it's clear and convincing. But I have to double check that. The statute is 18 USC section 3142. Are you quizzing me, or do you know?
I'm quizzing you.
You're asking, but are you asking me?
No, I'm legitimately asking you. No, I'm seriously asking you. I do not. That's why I was asking you. Yeah.
Well,
so I wasn't sure if it was just preponderance for both, or I couldn't remember. But I'm looking at 3142.
All of life's questions can be answered in these statutes. But by the way, 3142 is affectionately known as the Bail Reform Act. And it should be noted that this was ostensibly created with the intention that there'd be a presumption of release. In other words, that detention should be in sort of rare instances. And I just don't know if the reality plays out like that or not. Here we go. The facts a judicial officer uses to support a finding pursuant to subsection E that no combination or conditions will reasonably assure the safety of any other person and the community shall be supported by clear and convincing evidence. Yes, I was right about that.
So is it clear and convincing for both? Okay, here I got it. In a pretrial detention hearing, the government's burden is to establish by clear and convincing evidence that no conditions of release will reasonably assure the safety of the community. So you're right there. The standard is different when the issue is whether any conditions of release will reasonably assure the defendant's attendance at trial, flight risk. The government need only prove that there are no such conditions by a preponderance of the evidence. So that's interesting the way, now I'm reading from the U.S. Attorney's Manual, and it's interesting the way they put it there.
Yeah.
That the government need only prove that there are no such conditions by a preponderance of the evidence of flight risk.
Yeah, that's what I thought it was, but I'm not seeing where preponderance exists in 3142. So I don't know if it exists somewhere else or we've all just.
Well, they cite to an old Northern District of New York case.
No.
U.S. v. Tedder 903 F. Sup 344.
Yeah. Okay.
Yeah.
Well, then I was right. I get a
Yeah.
cookie because
Yep. You get a cookie.
and by the way, so the judge can make a finding that there's flight risk or danger, but that's not enough. They have to find then that there are no conditions that they could put into place
Correct.
that could remedy that. So it
Right.
really is like a two-step process, and that those burdens of proof, I think, go to the no condition or combination of conditions that will reasonably assure the safety of any other person and the community, because that's what at least 3142 says about danger.
Right.
So, and that's 3142. It's really kind of complicated. And then to add extra complications, and the reason why I bring this up is because, at least in the Ninth Circuit and a few others, I don't know that this is the case in the Second Circuit, but if the underlying offense that you're charged with, in this case, SBF, it's a white collar, it's a nonviolent, it's not a crime of violence.
Right.
And so there's an argument to be made in the Ninth and other places that if you're not charged with a crime of violence, you can't even have a discussion about danger to the community.
Mm.
But this does carve out a separate thing for witness tampering and
Right.
obstruction of justice and everything else. And of course, we know that's what SBF was accused of
Right.
here. So
And that's in 3142F, where
yeah.
there's discussion of obstruction of justice or threatening a witness. And
So
that
the
is what,
flight risk thing is interesting to me here, as it is in Trump's case, because SBF was not in the United States when this indictment came down. I think he was
correct.
what, the Bahamas
Is
or
in
something.
Bahamas. Yep.
And he has ostensibly billions, like all the money in the world, so he could go anywhere at any
Correct.
point.
Significant foreign connections.
Significant foreign connections, all those things that would give a judge concern that they wouldn't show up for court because they don't
Right.
have to. They could just live their life in some country without extradition. We've had this conversation about Trump too, that you don't think he that would qualify. I do. Like didn't, was it you were talking about, because he's like the most recognizable person in the world
Well,
right
not so much that we
now?
were talking about this, but it wasn't so much that he's the most recognizable. It's that he's surrounded by law enforcement constantly. The Secret Service would
Yeah.
not let him flee. So they're de facto U.S. Marshals, if you will. They're not going to let him flee.
I think you give the Secret Service way too much credit, because I don't know that their job is to do anything other than protect him. And if he wants to go, they just have to go with him.
Well, they're still law enforcement officials, and that's why a number of them readily testified to Congress and to the grand juries in some of these cases.
Yeah, but he's got some loyalists in the group too.
Well, that's a different issue. Yeah, I mean there could be, but just on its face, the Secret Service are law enforcement officers. They will not let him flee,
So
unless they're crooked or something like that. But that's
could he
different.
shake them, jump on Trump Force One, and fly to a country that has no extradition and live happily ever after?
Well, that would be interesting. Whether a judge might order, I don't know. I mean, they obviously couldn't order the military to intercept his jet, but he certainly would have a red notice.
The interesting thing is that we'll never know, at least not now, because the government never raised the issue, and unless they do, they don't
Well, I
have.
think the reason why they haven't raised the issue is because he's surrounded by Secret Service. But
All right, and
so
then there's the dangerous thing still on the table too, but we're getting off course probably.
right. And
So
one thing I just want to
yeah.
bring it back real quick to sentencing. Why is this relevant to sentencing?
Yeah.
Because if you are remanded, especially at the time that you're arrested,
Yeah.
that's when your sentence begins. If you're ultimately convicted, and as we know, statistically speaking, or 97% of individuals that are charged with a federal offense plead guilty, the rest go to trial, but the majority of them, over 80% of those that go to trial, end up getting convicted.
Yeah.
You have less than a 1% chance of being fully acquitted and walking. So your sentence can start the day of your arrest. Now, once you're remanded, all that time you get credited towards your sentence once you're actually remanded.
But there's a bigger problem here, which is now with the First Step Act and all these great new credits you can earn for doing wonderful programming
right
while you're serving your sentence.
you don't get that.
You're sitting in a pretrial detention, and the opportunities for programming in most of those facilities are slim to zero.
Correct.
So all that
That's
time
correct.
you're just languishing around waiting to be, to see your fate and to get into an actual BOP facility where you can start getting programming and start earning good time credit. I
That's
mean,
correct.
you will get good time credit probably for that
Yeah.
time, but not programming credit.
You're not going to get programming credit. No. I mean, it's hard. It's hard for many inmates to get programming credit now at BOP facilities because they're underfunded. I mean, that's a probably another podcast, but
Mm-hmm. Well, that's true too. That's true too.
so I mean, the big thing is if all it takes is for the government to show by a preponderance of the evidence that you're a flight risk, I mean, you can be sentenced under just a preponderance of the evidence. And by the way,
Yeah.
at your bond hearing, at your detention hearing, there are no rules of evidence.
Yeah.
Anything comes in. So your liberty is most at risk at that time that you are arrested. You
Yeah.
have almost no protection.
Yeah. That's gross. I mean, that
It
kind
is.
of links up to what we've been talking about with uncharged and acquitted conduct, which is
Yes.
you're getting hammered, and there's no
No due
presumption of innocence,
process,
there's
or
no due
very minimal due process.
And here's the other big part of the connected dots between pretrial incarceration and sentencing:
Mhm.
coercive plea bargaining.
Yes.
Because you may be innocent or have a really good defense, and that you really want to go to trial. And the government a lot of times knows this, and that's one of the reasons they're trying to keep you in custody. Sorry, but that's true. They don't
Yes, it is
really have
true.
a real concern that you're going to flee. They don't really have a real concern that you're a danger. They want a tactical advantage over you, which is to say, I'm going to lock your ass up in this piece of shit pretrial detention, and you're going to be a lot more receptive to the plea offer that I'm going to give you. And this happens, I'm telling you, this discussion with clients happens all the time, every day in every courthouse in America, which is, dude, I know you have a really good defense, and I really want to go to trial with you. The truth is, it's going to take X amount of time to prepare for trial, and you're going to stay in custody for this long. And, forget if you lose, you're going to go to prison for that long. But it's just a lot of times you're looking at probation or time served or something. And people, even innocent people, will just give up and plead guilty to get the hell out of jail because it's a nightmare to be in those facilities.
It's systemic coercion. That's exactly what it is.
Exactly right. Exactly right. And if you don't think that doesn't happen every day all over the country, well, you're not paying attention, because it does. I promise you, it does. And so, and that really kind of burns me, how pretrial detention really can happen at the drop of a hat in magistrate courts and, district courts and federal court. I love the fact that states are getting hip to that and changing their, doing bail reform. The federal government should be following suit, in my opinion.
Well, the one good thing about the feds is that generally, if bond is granted, there is no there's no requirement, or usually no requirement, to put up any actual money. And that has always been a problem at the state level for many defendants of lower economic means. They may not have enough money to make bond.
Right.
And so there's been a big push to get rid of cash bond requirements,
which I think is great.
Which is great. And at the federal level, generally, you're going to be released on on personal recognizance on what's called a signature bond, which doesn't require any collateral. It's just your signature, 25,000, 50,000, whatever it is. But that's it.
Most times you're not even going to get that. You're just going to be released with some pretrial supervision to make sure you're going to show up, and some conditions. So again, that's a restriction on liberty too, but it's better than being in jail. But Sam Bankman-Fried had what we call an unsecured bond, right? He didn't have a cash bond, but I think he had to sign.
No, I think it was a secured bond by his parents' property.
Oh,
it was a very significant bond of several $1 million.
Okay.
So it was an unusual case because he was such a flight risk, and that's why he was remanded. He basically got home detention. He was remanded to his parents' homes, or
Mm-hmm.
parents' home, and they're actually both law professors, as it turns out, from Stanford. So he has been sitting out once he returned to the States. I don't know how long it's been, several months, maybe almost a year now, but that's where he's been holding up, is in his parents' home in Northern California.
Don't you?
But it was, yeah.
Why didn't his parents give him some good legal advice then, if they're law professors? Like, hey, maybe not with the witness tampering.
Yeah, well, my guess is they probably were. And this guy, a lot of money and fame does a lot to one's ego, as we could see with Trump. And so my guess is he wasn't listening to mom and dad.
Yeah,
God knows my kids don't listen to me that much, and I don't give them billions of dollars.
yeah. My
So,
kid, yeah, that's true. But he's not really a kid though. He's isn't How old is that guy?
I think he's like in his early to mid 20s.
All right. So you know what?
He's
I'm gonna
31. Excuse me, he's 31.
he's 31. So he's
Yeah,
not a kid, but
he's not a
I
kid.
would posit, and I hope, that I'm sure his lawyers are looking into this, but I would posit that maybe there's something not totally right with him from a psychological standpoint. I don't know what that may be, but it's just seems like, I don't know. What little I know about him makes me curious as to
It's just like
whether he's,
Elizabeth Holmes.
yeah, like Elizabeth Holmes or
Mm.
Shkreli. Remember Martin Shkreli and everything?
Yes. Oh
Like
yeah, farmer
we
boy
just
or
we
farmer
just kind of
girl.
looked at him and what he was doing and the way he was acting. We made all these judgments about he's this, he's that, he's a bad person. I think there's just something going on in the brain that might account for a lot of this odd behavior and bad choices. That's as
Yeah.
much as I say about that.
Yeah.
You have prepared a very beautiful PowerPoint presentation for today, and I hope it's super compelling. I have no doubt that it is super compelling, but
Well, I don't know where to start or where to go. But
where do we
well,
need
actually,
do we need the PowerPoint? What else
well,
would
what,
we talk about?
well, one of the things I do want to talk about though is revocation. When,
Yes.
once, so you've made bond, you've been released, you've had your
Yeah.
detention
You're
hearing.
living with mom and dad. Life is good.
You're living, yeah, you're living with mom and dad, or you're living down in Mar-a-Lago. You're running for president and what have you. And now something happens, and the government moves for to revoke your release, to have another detention hearing, essentially, and to revoke your freedom, get you in prison pending, or in jail, I should say, pending trial. So what I did is I went out and I was curious about this, and I was like, how frequently does that happen, where the government moves to revoke bond?
Yeah.
And not generally in those cases, bond is revoked, but not all of them. But I was just curious, how often does the government move for it, and is it different from offense type to offense type? And
And by
this
the
was,
way, I've been practicing in federal court almost exclusively for more than 20 years, and I'm can't remember one case where I've had a government move to revoke bond. I'm sure that it's happened once or twice, but it doesn't. It really is, in my experience, almost non-existent.
oh, really?
Yeah.
Well, it exists.
Maybe that's because all my clients were already in custody. I don't know.
Probably. Well, there you go. If they're already in
That's
custody.
not true. I got a few of them now.
So,
Yeah,
well,
okay. So you're
okay,
gonna
so
say it's more prevalent.
yeah, it's, well, it's not very prevalent. So, but it does happen.
And by
So,
the way, just so we're talking about, I'm not here to bag on prosecutors. There's definitely a few of them out there that I really respect, but this back to this tactical advantage, it's not
yeah,
just about coercive plea bargaining. It's that it really, really makes it very difficult to prepare your case for trial when you're in custody. Especially like think about all the documents that in a white collar case, like
mhm,
terabytes of stuff. It's very hard to get access to computer. Your lawyer can't really have great
right,
conversations with you over the
right,
phone. The lawyer's got to come down there and meet with you in person. Sometimes those jails are located very far away from
yeah,
where the district court. My jail in the District of Arizona is an hour and 15 hour and a half outside of town. So if I want to talk to a client, I have to do that, or I have to go down, do some kind of crappy video conference.
Yeah.
But it just makes everything harder. And
Yes.
the government knows this.
Yeah.
And it's all a benefit to them. Sorry to say. Go ahead.
Oh, yeah. That's all that's true. So what I discovered. So since I just thought I'd look at the last 5 years, almost 5 years, beginning on January 1, 2019.
Yeah.
So beginning on January 1, 2019, there have been 556,081 federal criminal cases initiated. So these are all the cases that were initiated on January 1, 2019 or after. Of those cases, revocation of bond was sought in almost 10,000 of them, which really isn't that big, 9,926, which means nationwide there is a bond revocation rate over the last 5 years of just 1.8%. So in other words, in 1.8% of federal criminal cases across the board over the last 5 fiscal years, the government sought revocation of bond. Now, I wasn't able to determine, at least easily, if bond was revoked in all of those cases, but most of the time it was. And I'd say just an educated guess is probably at least 80% of the time was bond revoked in those cases. It turns out that one of the highest districts, and I also looked at the district level. So one of the highest districts, or I should put it this way, the Western District of Texas had the second most number of cases overall. So again, there was 500,000 over the last 5 years. The Western District of Texas had the second most, second only to the Southern District of Texas, which should surprise anybody because of all the immigration, all the border case. But there in the Western District of Texas, they had the number one, the highest revocation of bond. The government sought the most revocations of bond than any other district, 1,201, which means that overall for that district, it was 2.2%. That was the bond revocation rate, or that was the rate at which revocation was sought, if that makes sense.
How are you finding this? I just want everybody to know, because Mark Allenbaugh is sentencingstats.com. This is what you do.
Yes.
But this is a kind of an esoteric set of stats. Like, this is not something we commonly look for. And I don't know if you want to reveal your magic, your potion, but I'm super curious to know how you know all this stuff.
We here in the Sentencing Stats Lab, all we do is think about data, how to find it, and how to analyze it.
All right. We'll leave it at that.
We'll leave it at that.
Shocked that it is wild that you know these stats. This podcast, again, brought to you not really by Wild Common. And I don't know if you'd call those revocations common or not. It sounds like 1 or 2%.
Well, no, they're not. So that's a good, speaking of Wild Common, no, they're not. They're not.
See, I can make everything relevant to sentencing, and I can make everything relevant to tequila.
There you go. Good.
That's my magic power.
Excellent. Okay. So now I wanted to look at basically what Sam Bankman-Fried is, how rare or not was it that he got his bond revoked? So I looked at all wire fraud. His primary charged offense is wire fraud, and a number of charges. And he also has money laundering, a bunch of other stuff. But I just thought, let's just look at wire fraud, classify his case primarily as wire fraud, because if he's convicted, it's going to be sentenced like a wire fraud case. So there have been 8,865 wire fraud cases initiated nationwide since January 1, 2019. Bond revocation was sought in only 375 of those. So a slightly higher, actually, a slightly higher rate. That was a 4.2% rate. So slightly higher than the nationwide average of 1.8%. The Southern District of New York, where Bankman-Fried, the case is being prosecuted and where he has been remanded, it ranked as having the second highest number of revocations sought at 577. Oh, no, excuse me. No, it had the second highest number of wire fraud cases in the nation, second only, I think, to the Eastern District of New York. And they had 577 cases. It ranked only 8th, though, in the number of bond revocations, only 13. In other words, the government over the last 5 years has sought to revoke bond in wire fraud cases in the Southern District of New York only 13 times. And so that's a rate of only 2.3%.
Wow.
So it's about equivalent to the national average overall, which was 2.2%. Or excuse me, the Western District of Texas, which is a really big district, at 2.2%, a little bit more than the nationwide average of 1.8%.
Yeah.
So here's what's interesting. So everyone's eyes are glazing over, so I'm going to try to make this a little bit more relevant. Let's look at witness tampering, which is the primary, or one of the, I'll put it this way, it's one of the, or two of the charges that Trump has been charged with. And it may be what he may be looking at a superseding indictment for additional witness tampering, given his conduct as of late on Twitter and what have you, or on his Truth Social. So I looked at witness tampering. There's been 4,743 cases nationwide since January 1, 2019. Bond revocation was sought in 560 of those. That is a rate nationwide for witness tampering of 11.8%. That's significant. That's almost 3 times higher than it is for wire fraud. In other words, looking at wire fraud and witness tampering, you're 3 times more likely to have the government seek to revoke your bond in a witness tampering case than in a wire fraud case. That is huge. So
and to give the government credit where credit is due, I can understand that, because
why?
If they're truly out there interfering with the prosecution's case and trying to chip away at it by obstructing justice and everything else, then I would see where I'd need to kind of neutralize the threat level there. And if I'm the lawyer,
well, they're already charged. So let me make it clear with witness tampering. They're charged with some type of witness tampering. Okay, they're out on bond on those charges.
Oh, they're already charged with witness. I thought you were saying the basis for the revocation.
No, this is the basis for the revocation. It could be anything that they have.
We don't know why those witness tampering people who are charged with witness tampering, what they did to get their bond revoked.
Correct.
I got you. I didn't. I must have tuned you out for just a second.
It's easy with all these numbers being thrown around. So the point being, whatever the reason, the government seeks revocation of bond 3 times more frequently, or 3 times as often in witness tampering cases than in wire fraud cases.
Okay.
So then I look just at the District of Columbia, the United States District Court for the District of Columbia, which is where Trump is, one of his 4 indictments is at right now, for witness tampering. And it turns out that DC has had more witness tampering cases in the last 5 years than any other district by far. I think I think the second highest was the Central District of California, and it was like 180 or something like that. So DC, if they like to bring witness tampering charges in DC. Now, of those 321 witness tampering cases over the last 5 years, the government sought revocation in 40 of them, which means there's a revocation rate of, or that the government sought revocation in 12.5% of those witness tampering cases. That is huge, considering when you look at wire fraud, wire fraud in the Southern District of New York was only 2.3%. So this is like almost 6 times as much, 6 times high in the District of Columbia. And at 12.5%, that's way higher than the national average overall, which was just 2.2%. So the point being is Trump is in the worst district for witness tampering. For those who have been charged with witness tampering who are out on bond, he has the highest chance of getting revoked in this district.
But I forget, does he have a witness? Does he have a witness tampering count on his indictment? Oh, yes. Okay, that's right. Well then. So if I'm going to Vegas and I'm putting odds, I'm a gambling man.
Yeah.
His odds are the worst in the district where he is now charged.
Correct.
Okay. Well, that's going to be
better for him if it was brought down in, the middle district of Florida, or even up in the Southern District of New York. But he got the worst of the worst.
Which makes it even more interesting that he's so far totally avoided any scrutiny for his alleged witness tampering endeavors,
Yeah.
like or whatever. But okay, so that's interesting. So I guess it looks like you got some tweets up there. You
Yeah. So
What was the witness tampering allegedly that SBF was doing that got his bond revoked?
this this was one of the things. Can you see this New York
Yeah,
Times article? Yeah.
yeah. I
So,
can see your whole PowerPoint, including all the other slides. If you,
uh,
I don't know if you're in presentation mode, but
oh
it's
yeah.
fine
Oh,
the way it is too. There, it's
yeah. It makes it easier for me.
oh,
Everybody can see too, so it's fine.
okay.
But yeah, so this shows what you're looking at here is the article that was written by a New York Times reporter on. I guess SBF had given this reporter some of his ex-girlfriend's diaries. She was the one that was running Alameda, which was the sister organization
Mm-hmm.
to FTX, and she's supposedly going to be one of the top or the number one witness against him at trial. She has been charged too. I think she is out of custody. I don't think she's been remanded. She is cooperating. And as soon as this was published, the government moved to revoke his bond. It was for this, as well as SBF had been contacting another witness, the former general counsel for FTX. And there's been a series of stuff. This wasn't just it. It wasn't just these two acts. There have been a series of pushing the limits that SBF has been doing while he's been on home detention. And it's everything from accessing a VPN. A VPN or a virtual private network is something that can hide where you physically are. It hides your IP address.
But he claimed he was just doing that to watch like some
To,
footballers.
to watch football. And what the government pointed out in its motion is this football game could have been watched on any regular television. You did not need a VPN to access this football game. It was being broadcast on ABC or ESPN or something like this on TV.
Right.
So, so he must have been up to something else. So that was just one example, but there was many other examples. He was contacting wrong people.
That's probably an interesting kind of side note, which is when you're charged with a fraud type offense, they're going to default to you're full of shit.
Yeah.
And even if it's true that he just wasn't thinking about it and pulled up the VPN because that's what he's used to watching his stuff, they're going to default to you're a liar because this is a fraud case and that's what fraud is. So we're not going to believe you.
Right.
Period. And that sounds a little silly on its face too, which adds insult to injury. But
we can see here. This is the motion. The Southern District of New York, by the way, has this weird, unique practice of letter motions. You don't move the court. You don't file a regular motion. You send a letter to the judge. Oh. Yeah, it's very odd. But at any rate, so
dear Judge Kaplan, it starts. Yes. I'm not kidding.
That's exactly the way.
How are you? Start. I am fine. I am writing to let you know that summer camp was cool and Sam Bankman-Fried is in big ass trouble.
Right.
Sorry.
Well, yeah. So what they write here is that the defendant's attempts to tamper with witnesses and interfere with the government's and public's right to a fair trial and due administration of justice, and his pattern of circumventing his bail conditions in that pursuit, the VPN stuff, and contacting other people on. He used something called Signal, which is like a WhatsApp app, and it or what the kids use, Snapchat, similar to that, where the messages disappear and all this stuff.
Yeah.
And it's all encrypted. So he was circumventing his bail conditions, demonstrate that no set of pretrial release conditions can adequately assure the safety of the community, and that the defendant is unlikely to fully abide by any condition of release. And now I'm just looking at the next page of this letter motion, and one of the things I have highlighted here is that on January 15th, the defendant initiated communication with the current general counsel of FTX, who may be a witness at trial and who is represented by counsel. And he wrote to him on this Signal, I would really love to reconnect and see if there's a way for us to have a constructive relationship. So, I mean, there's really nothing threatening per se about there, but he's not supposed to be contacting witnesses, just like Trump, by the way, just like Trump.
And I thought Signal was supposed to make those messages disappear.
Yeah, well,
But this is a challenge with white collar clients sometimes, is that They're overachievers. They're go-getters. They don't get to this position of great success and wealth without really like taking initiative, and they kind of take the bull by the horns. And as a lawyer who wants to have control over their client, it's very difficult sometimes. I'm sure the lawyers are pulling their hair out that he's
Yeah.
doing all this stuff behind the scenes.
Well, I'm sure what happened was the general counsel took screenshots of all
Yeah.
this interchange and gave it
Yeah,
to his
yeah.
counsel. So,
Right.
so that's what happened. And this just the SBF wasn't thinking. And then here is this was I think this is on page 2
Well,
or
that's
3 of
another good practice pointer. If you're doing something shady and it involves someone who's a witness in the possible witness in the case, or God forbid a co-defendant, you should just assume that they're
Yes.
going to turn on you and use that, because everything is currency in the federal system, and it's always a rush to see who can cooperate the best and the mostest to make sure that they don't have the full weight of the federal government crashing down on them. So Sam Bankman-Fried, as smart as he might be, didn't really think that one through.
No. And then with respect, and I just want to read this because it's we're going to go to some Trump tweets or
Yeah.
truths as he calls them here. But
And
what's
I'll
really
tell you
interesting,
what, I'm sorry to keep interrupting, but I'm
no,
just feeling like if I had a client here and I was advising him, if I knew that they did this, I would say, doesn't sound really terrible on its face, but you need to understand even the stuff that you don't think can get you in trouble is going to get you in trouble. So just don't do anything,
right, right,
period.
right. Don't push the limits. You're lucky to be out, but he kept
Yeah.
pushing and pushing. So
And now
what
he's
the second issue that the government raised was this article, this New York Times article about Carolyn Ellison, his ex-girlfriend. The article quoted documents that offer new insight into Ms. Ellison's psychology during the final months of FTX and described the writings as raw and or personal and raw. And so the way the government interpreted this is Sam Bankman-Fried is trying to
hurry
sway
her up.
possible jurors
Yeah.
against her so that she's a nutcase.
Yeah.
So he wasn't directly threatening her, but what he was trying to do was intimidate and influence her and possible jurors and how they viewed her.
Yeah, because
Uh,
now there's a New York Times article about this woman
yeah,
with some hanky stuff in there.
right, right.
He's banking on the odds that some of his jurors know about her from reading this article, and they will have made their own determinations about her credibility based on this stuff that he's giving. I mean,
So
what other reason would he have to share this stuff with the New York Times?
exactly, but one thing I do want to make before we move to Trump, I want everybody, well, not everybody to understand, at least the way I look at this. It's interesting that these were not direct, clear, unadulterated threats. They
Mm-hmm.
were just merely, can we get one was, can we get along with this respect to the general counsel? And the other wasn't even directed directly. It wasn't any communication with
Right.
Ellison per se. It was with the New York Times reporter just to kind of paint her as a nut job. But there was
Right.
nothing, nothing that Bankman-Fried was doing to directly address her, directly communicate with her a threat. Don't you dare
Yeah.
testify against me.
Right.
So this resulted just these
I
kind
mean,
of innuendos.
if
Yeah,
anything, it would make her more willing to go to court and
right.
go after him,
He's
because he
poking the
just
bear.
smeared her in the New York Times. Yeah,
Yeah,
totally poking the bear.
yeah. So then here we see Judge Kaplan did issue an order to remand him
Hmm.
because there's probable cause to believe that the defendant committed the federal crime of attempted witness tampering.
Uh-huh.
And so there's no condition or combination of conditions that will assure that the defendant will pose no danger to other persons or the safety of the community. So now keep all that in mind. What Bankman-Fried finally did, and in everything that he did that led up to this point, I'm not aware, and I don't think there's anywhere that's been alleged that he directly threatened anybody,
Mhm.
let alone the judge. So with
Right.
that in mind, what's really interesting is this little motion that was filed in Trump's case on August 4th. And this
Yeah.
was just a protective order. And the government was just moving, was moving for a protective order to preclude Trump from sharing a bunch of discovery out in, on Truth Social and whatever else he was going to share on. The reason being was the government was concerned about influencing not only jurors, but influencing witnesses and embarrassing witnesses and trying to get witnesses not to testify and all this other stuff. But what they did, though, is they pointed out this particular tweet that Trump issued shortly after he was indicted.
Okay,
all
read
caps,
that.
if you go after me, I'm coming after you. I cannot think of anything more directly threatening to every witness than something like that. And that he has, and I, frankly, any other J6ers that had done something like this, or any other defendant that was out on bond, would have been remanded.
Any of our clients, and if there's
exactly.
You hear the right talk about this two-tiered system of justice, and they're talking about it where in their world a Trump gets indicted and Hillary doesn't is a two-tier. No, this is the two-tiered system of justice. Trump gets to say whatever the fuck he wants, and thus far not be held to account under the,
and not even going after witnesses. But what's here, what's up on the screen now are a couple of these truths. I call them truths because they're on Truth Social as opposed to tweets. His fake Twitter account, or I guess it's X now. I can't keep track of all this crap. But he goes after the judge. And he writes that the following truth is a quote by highly partisan Judge Tanya Chutkan, angrily sentencing a J6er in October of 2022. She obviously wants me behind bars, and in all caps, very biased and very unfair. And then he does have a quote from her that basically she says that, well, I'll just read it, or read some of it. I see the footage of the flags and the signs. This was at a sentencing. I see the footage of the flags and the signs that people were carrying, and the hats that they were wearing, and the garb, and the people who mobbed that Capitol were there in fealty and loyalty to one man, not the Constitution, of which most of the people who come before me seem woefully ignorant. Not to the ideals of this country, and not to the principles of democracy. It is a blind loyalty to one person who, by the way, remains free to this day. Now, that does seem a little, biased, frankly. But on Judge Chutkan's part, but the fact that Trump is able to make these very glaring, there's no innuendo to them. They're just very glaring threats directly to witnesses, to all witnesses, and to the judge herself, and not have been remanded yet. It's just shocking to me, especially when compared to what SBF, what he did, which was nowhere close to this. And he got remanded, sharing some diaries, asking, hey, the general counsel, his ex-general counsel, hey, can we get along? Maybe we can help each other. Nothing threatening, just communicating. There was a lot of innuendo there. I'll put it that way. There's no innuendo to what Trump's trying to do here. And we know, by the way, too, that as a result of some of these truths, there was a woman who called up Judge Chutkan's chambers and threatened to kill her, and used all sorts of invectives and just the most vile language. And she is now she was arrested.
Got arrested.
Federal charges too.
His words have always had the power to incite violence. And he knows that. We don't have to guess about that. Because honestly, 1-6 doesn't happen without his words, without his tweets. It'll be wild, all of this. So he knows very well what he's doing. We all know very well what he's doing, and we all know the power for bad things to happen. So the question still remains, why is everybody treating all this with such kid gloves?
Well, I think I have, federal judges, in my opinion, are often the most smartest chess players out there. And the way Judge Chutkan is dealing with this is, rather than remanding him, which might cause even more problems and more issues, just logistically, where to put him and Secret Service and all this other stuff, rather than dealing with remanding him, what she said is, this is going to make us go to trial even quicker. And I thought, you know what? What a novel way of dealing with this. Normally, you would just say, look, okay, I'm going to remand you. And now your attorney's going to take time to get, ready for trial and all this stuff. And, 6, 7 months from now or a year from now, we're going to go to trial and you're going to be languishing in a jail that whole time. For whatever reason, she doesn't think she could do that or doesn't want to do it yet. Probably a better way of putting it. And rather now she's put a shot across his bow and said, well, look, this is reason just to go to trial even quicker. Now, I like that. Why not do that for other defendants, though, rather than remanding them?
Here's why I don't like it. It's a due process thing. It's really untethered to the facts on the ground of how much time he needs to adequately prepare for trial. And I understand that his mouth could get that's the consequence of his mouth, but and I think she's doing it in hopes that would get him to cool it because he needs more time. But I don't want, like, I'm not sitting here saying I hope Trump goes to jail. I hope this, I hope that. I only always want, and I've said this before, and I mean it from the bottom of my heart, I only want him to be treated the same way that the majority of my clients are treated.
Yeah.
And we know that if our clients did half of what he did, he'd be waiting in jail for trial.
Yes.
When Trump did that thing, if you come after me, I'm coming after you.
Yeah.
And I got in my wild narcissistic fantasy, I'm the judge in that case. I'm sending the marshals. I'm putting him in chains. I'm bringing him into court. I'm having a detention hearing. I'm ultimately going to let him out again. But I want him to taste the bitterness of what life looks like if he keeps up this bullshit. Because I think that we're going to make your trial happen a lot faster as an idle threat. Because if I'm going to appeal, if that's an appealable issue, that I didn't get the time that I need to prepare for trial because the judge is mad at me because I have a big mouth. And I just think he needs to, I think he just needs, if the reality is not setting in of how serious this is, he needs to have a little reality check. That's what if I'm the judge in my world.
Yeah.
And then if he doesn't get it after that, I'm going to give you another chance for sure, but I'm not going to give you much more than that. And
well, his invectives seem to have calmed down. The direct threats, at least to witnesses and mention of Judge Chutkan or any of the other judges, hasn't appeared in the last several days, at least on his Truth Social. So, maybe he is starting to get the message here. And maybe that was enough to scare him. We'll see.
Yeah.
But I never doubt Trump's capacity to shoot himself in the foot.
And the last thing I will say is I won't name names, but in my travels this week, I came across a Secret Service agent. I met someone who worked for the Secret Service, and they don't talk. They're not telling me anything. But I said, I'm going to tell you what I think needs to happen here, because everybody's like, we can't. And this is really underlying the whole conversation. Why doesn't he go? Why can't we put him in jail for this or a pretrial? And everybody's like, well, what are we going to do? He's the president. Are the Secret Service going to have to be posted outside his jail cell? And like, how are the logistics? And he can't be with general population. He's got to be protected. And it's just too much logistically. And because it's too much logistically, he gets a free pass. That's how I interpret this whole thing.
Yeah. It's good interpretation.
But that's, to me, I'm like, there's a solution to every problem. And I said to the Secret Service, I'm like, if he ever did get convicted of something, presumption of innocence, great. And he had to be sentenced to prison. What we're going to do is we're going to do forfeiture proceedings on Mar-a-Lago, because that's a fruit or an instrumentality, or he's going to owe money for one of these crimes. Basically, the federal government could seize that entire property and own it forever as part of a criminal case. Very easily, I think. And then we turn Mar-a-Lago into a one-man private prison. And I'm not talking like trips to the omelet bar and hanging out at the pool and girls coming to visit and whatever. I'm saying we're going to make a real simulated prison there. Nobody's going to have access to him. His Secret Service can guard him if they want to. And, when his sentence is done or he drops dead, then we turn that place into the Museum of justice and democracy.
Well,
And
you know what you're describing, and I'm surprised nobody has brought this, at least that I've heard, this example up from history. Rudolf Hess, the Nazi war criminal, he
okay.
was housed in Spandau prison for 40 years before he was hanged. He was the only inmate at that prison because they had nowhere else to put him. So basically, you're talking about turning Mar-a-Lago into Spandau prison.
Yeah.
And there's some precedent for that, not U.S. precedent, but there is precedent.
And then after that, a museum
And a museum, yeah.
democracy. We want future generations to understand how we almost lost our democracy.
Yeah.
And come make a pilgrimage to this site.
In lieu of a Trump presidential library, it would be that.
Mm-hmm. Yeah, that's my proposal.
I like it.
And the Secret Service just looked at me and she nodded and she walked away. I think maybe she was reaching for her sidearm just in case. I'm not sure. But I survived to tell the tale. But you know what? If that ever happens, we've said it here, I'm going to get full credit.
Yes.
Because I need that. I have a very fragile ego.
We should call it Spandau-a-Lago.
Spandau-a-Lago. Is there any connection to Spandau Ballet?
Yes, I'm pretty sure there is. Yeah, Spandau is a city in Germany.
Interesting. Yeah. And they had to keep him in isolation because why? He was just so popular that they didn't want him to influence the other inmates.
I have to go through the history. I'm not sure why, to be honest with you, but
I'm intrigued by that.
Yeah.
I'm intrigued by that because in truth, though, when you think about if the danger that we're talking about are his communications,
yeah,
as long as he has access to the outside world, he will ostensibly that danger will always exist.
Yeah.
And so you have to have if he were to be incarcerated, he almost would have to be isolated.
Yeah.
To do that.
Yeah.
But of course, that in and of itself will rile up the base. There's danger any way you slice it, I'm afraid.
Yeah.
And I am afraid.
And I'm with you that when it comes to justice, there is no cost benefit analysis. Justice is justice. It
is what it is.
Exactly. Yep.
Yeah. Okay. Well, that's a good place to end our discussion. But I guess if we want to make this practical, I will say this. I think that if you have to deal with a bond revocation or even just a bail hearing in general, I want you to think about the narrative. I want you to think about this as if it were a trial. I want you to think about pulling out all the stops to make sure the judge understands that there's a real live human being and the consequences of putting them in pretrial detention are huge.
Yeah.
And I know people that even have done videos. We talk about sentencing mitigation videos, which of course is my thing, but they're not just for sentencing.
Right.
I've seen them be very effective at bail proceedings, plea negotiations. Don't.
And this is the first opportunity. For the judge to really get to know the client, the defendant.
Exactly. So, okay. So we did pretrial release. That's good. Important topic. I want to say thank you, as always, for spending a Sunday evening with me. It's time for you to get back to whatever you're doing on Sunday night, and I'll talk with you soon.
Okay. Well, thank you, Doug.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.